All right, let's give a start. Let's invite the administration in.
會議議程一呢
Item 1 on the agenda, confirmation of minutes. The draft minutes of the meeting, which is CV Bracket 3, 303/1415, was issued to members for perusal on the 24th of December 2014. If there is no objection, I'll confirm the minutes. Thank you. Issues raised at the last meeting. Well, the weather is getting warmer today. Maybe the administration is a bit slow in coming in. And the list of follow-up actions. About the issues raised at the last meeting, the administration has given its response. And their response is together with the issues raised are set out in papers CB Bracket 305/1415 Bracket 01 and 02. I wish the administration a happy new year, and we have from the Food and Health Bureau Ms. Christopher Wong, Deputy Secretary, and Ms. Hinny Lam, PAS for Food and Health, and Ms. Jean Chang, Assistant Secretary for Food and Health, and Dr. Thomas Sitt, Assistant Director from AFCD. And these are officials from the Food and Health Bureau. So, Mr. Wong, would you like to walk us through the two papers? Thank you, Chairman. Good morning, members. Well, the first paper is a response from us to issues raised at the meeting, at the last meeting, and we supply supplementary information as requested. In relation to the dates or the periods, terms of office, the members have asked the administration to provide information on the terms of office of the chairpersons and members of some other statutory bodies in Hong Kong, which is similar to the VSB, and we have included information about the Medical Council, the PPB, the Chiropractors Council, Architects Registration Board, Engineers Registration Board, and Social Workers Registration Board, so on and so forth. And the terms of office are set out in Paper A. Annex A. For most of these councils, the term of office is 3 years. And also at the last meeting, members asked, under the VSB, the actual term of office, and in Annex B, we set out the actual terms of office for chairmen and members since the establishment of the VSB in 1997. Our previous practice is to have a term of office of 3 years. Some may have a period less than that because of early resignation of some members or chairmen for personal reasons, and we will then appoint other members to fill the vacancy. And at the time of appointment, some members might have requested a shorter term of office, but normally the term of office is 3 years. And judging from past experience, we consider that a term of office of 3 years should be sufficient in allowing chairmen and members in familiarizing themselves with the operation of the VSB and for them to make their contribution. So we find the 3 years three-year term appropriate, and we have kept the same arrangement in the bill. As for the appointment of members, each member should not hold office for more than a term of 3 years, and we have given flexibility when we ask prospective members whether they're interested in being appointed, and should they wish to have a shorter term of office, we can do so. As for appointed members, we believe that the reference term of 3 years should be adopted. And there is also transparency. So in the bill, we propose that for elected members, the term of office should be 3 years. At the last meeting, members also asked that in the case of casual vacancy of the VSB, whether a by-election should be held within a certain time frame. And Chairman last time asked us to make reference to the LegCo and DC elections. And in our response, we have set out that in accordance with the CAP 541D, the EAC Electoral Procedure Electoral Regulation, the Chief Electoral Officer must, as soon as practicable, publish in the Gazette a notice to hold a by-election, and the notice must state the date on which the by-election is to be held. Similarly, for the DCO, District Council's ordinance, there is a similar arrangement to fill a vacancy in the membership of a District Council, and that a by-election should be held as soon as practicable. And for LegCo and DC regulation, there is a similar arrangement. If a vacancy arises within 4 months preceding the end of the current term of office, then the by-election must not be held. And our bill contains a similar provision. In the case of a vacancy, the board must, as soon as practicable, hold a by-election under the election regulation. One difference is that a by-election will only be held if the term of office is 9 months or more. So we have considered the fact that the VSB membership is not the same in nature than the membership of a DC or the Legislative Council. So we have set the term of office at 9 months, because we wouldn't want the candidate returned in a by-election to have too short a term of office. A member also asked the estimated cost of holding an election of members to VSB. As the cost for holding an election may vary depending on the mode, scale, and requirements of the election, and we have yet to finalize the arrangements for the election of the VSB, we are unable to provide at this stage an estimated cost for the election, but the cost will be borne by the government. Lastly, at the last meeting, we mentioned that we're going to add a new section 17A, which allows the VSB to set up a PIC or inquiry committee. And as explained last time, the purpose of establishing a panel of assessors, it should be a panel of assessors to provide a pool of talents whereby, as and when required, to take up positions as members of the PIC or the IC, to carry out investigation into cases of professional misconduct. And as stated in the new section 17A, the panel of assessors is to consist of not more than 12 registered veterinary surgeons, not more than 6 other persons. This section does not provide a minimum number of assessors in order to give the VSB a greater flexibility in making appointments. So we have only proposed a cap of 12 registered veterinary surgeons and 6 other persons. Thank you, Chairman. And that's all. Any questions from members? I'll allow members to ask questions before we resume clause-by-clause scrutiny of 17A. Dr. Ann Chang. Thank you, Chairman. I'd like to follow up on this point. On election of members of the VSB, the electoral method will only be decided later, so I won't spend too much time in examining this at this stage. However, I hope that the arrangement will follow the EAC's requirements, and it should also be subject to the ICAC requirements on clean election. As for the cost, well, you can't give us an estimate, but we don't want to increase too much a burden on the public coffers. So perhaps in the future you may not set up too many polling stations. There could only be just one polling station, take it or leave it, so as to save public money. As for point C, well, in 17A, it says that the panel will consist of not more than 12 registered veterinary surgeons and not more than 6 persons. I think if you want to have a larger pool of talents to address the issues concerning case appeals and to expedite the board's work, you can consider increasing the number of other persons to up to 12, so that you can have a larger pool, and yet if necessary, you can have more manpower available. Because for these other persons on the pool, I don't think they would mind, because their help would only be sought when it's really necessary. I think they'll be more than happy to do that. So these are the several points from me, Chairman. Any response? Thank you, Chairman. Thank you, Dr. Ann Chang. About election, as members note, there will be another election regulation, and if the bill is passed, then under 28A, the Secretary for Food and Health will be empowered to devise the election regulation. However, at the last meeting, some members suggested that we provide you with some ideas on the election regulation, and we have submitted another paper to the Bills Committee. So if chairmen agree, in a moment we can also walk through that.
We want the election to be fair and just as far as possible, and I would also like to rationalize the cost. So we want it to be transparent, simple, and easy to administer. When we brief members on the election arrangements, we can have further views from members. I think we can deal with the next paper by the time we reach clause 13. So for matters related to elections, please keep them until we are at clause 13, okay? Or section 13. Chairman. Well, I'd like to know the professions of lay members appointed in the past 3 terms. I believe we've got it. Yes, at the first meeting, at the request of members, we presented a supplementary information paper. That's fine. Perhaps I've overlooked it. I can check that. Dentists and lawyers and so forth. Some deputations asked whether there can be representatives from all 3 professions. because sometimes an operation may go wrong in anesthesia. So, what about the representation of animal lovers? Ms. Lam, do you have anything to add? Dr. Jiang talked about the panel of assessors. She asked whether we can increase the number, increase the cap of other persons. We will reconsider this. All right. If we are done with paper 305/02, we'll return to our clause-by-clause scrutiny. We were at clause 1117A. Yes. We were at clause 11, adding 17A, section 17A and 17B. 17A is about the establishment and membership of panel of assessors. We touched on that in our previous paper, and perhaps I will spend no further time on this. Yes, please go on. 17B, term of office of assessors. Because the panel of assessors will be appointed by the board, and we suggest that the term of office will not exceed 3 years, same as that for the board, or even shorter, because the appointment of assessors can only be done upon establishment of the board, and the term of the panel of assessors should coincide with that of the board, ending on the same date. Subsection 2 of 17B. If the office of an assessor becomes vacant under Section 2E3 of Schedule 1 before the term of office expires, the point may appoint on the nomination of the director of AFC a person who is of the same category under Section 17A2 or 3 as that assessor to hold that office for the unexpired term. In other words, if the assessor is a registered vet, then the same must be appointed to fill that vacancy. And if the assessor is from the category of other persons, then the newly appointed assessor must also belong to the category of another person. Dr. Jiang, I'd like to know whether the ratio is 1-to-1. That will be dealt with under Section 17C, and that's the establishment or composition of the PIC. Yes, please go on. When the board receives a complaint, the Secretariat will refer it to 2 members of the board, one of which must be a lay member. And then a PIC will be set up to decide whether the case should be referred to the inquiry committee or IC for consideration, or whether it should be rejected. In making this decision, the ratio of vets to non-vets in the PIC should be 2-to-1. And we propose in the bill that the PIC should have 3 members. There can be different combinations. Either all 3 members of the PIC should be members of the board, or where there is a shortage of manpower, the PIC can be formed by having 2 members of the board and 1 member from the panel of assessors to lessen the manpower burden on the board. At any rate, the ratio of vet members and non-vet members in the PIC, regardless of the combination, should be 2 to 1. Well, in an IC or in an inquiry, the ratio is 1 to 1, but now it's changed to 2 to 1. I urge the administration to reconsider, because at the PIC stage, it involves some kind of accusation against a vet. But this is not really an inquiry. It's just an investigation committee. The PIC will see whether there is any case for the complainant or the complaining to answer. So are you saying that even at this stage, the ratio of vet to non-vet members should be 1 to 1? That's correct. It's true that under the current mechanism, there are only 2 members in the PIC, and of course the ratio will be 1 to 1, 1 vet to 1 non-vet. However, the PIC is not tasked to make a formal decision. It will only decide whether a case should be referred to the IC for a formal hearing. And in the full board, there are 10 members, member plus the chairman plus 9 members, and the ratio among the 9 members are 6 non-vet members to 3 non-vet members, and the ratio is 2 to 1. As members may recall, the purpose of the bill is to simplify the procedures. So after the PIC has done its initial investigation, it can then decide whether the case should be referred to the IC for a formal hearing. In this regard, it has replaced the board in making this decision, and therefore we propose to keep the ratio of 2 to 1. Now you have to understand Dr. Anne Chang's concern. She doesn't want the profession to defend its own profession or members of the same profession. When the ratio is 1 to 1, then the situation is 50-50, and then the board can make a decision. But if the ratio is 2 to 1, if the 2 vet members decide to protect the vet being complained against, then even if the non-vet member wants a formal hearing, the case would be quashed at this stage. So how do you address the concern? Then the vet profession may be there to defend its own members. We do appreciate this. The current situation is there are 2 members in the PIC, and they may not agree on a certain case. And if there is no consensus on whether a referral should be made, the case will go back. So for sure there will be a referral. Because the case is undecided, the case will be referred back to the board. So whether it should be whether it is 1 to 1 or 2 to 1, when there is no consensus, the case will always go back to the board. Well, at present, because there are only 2 members, when there is no consensus, the case will go back to the board. But in future, if it is 2 to 1, then the majority will prevail. This is exactly Dr. N. Zhang's concern. if if in a case a pet is advised, or pet owner is advised to do certain procedures for his pet, and that constitutes a complaint. In the past, the ratio is 1-to-1. When there is no consensus, the case will be referred back to the board. But in future, the ratio is 2-to-1, and if the vet members there want to protect members of their same profession, then it may not be fair to pet owners. I believe the majority of complainants will be pet owners. Will it be fair to pet owners if the ratio is 2-to-1? And I think Dr. Jiang will be happier if the ratio is 2 non-vet members to 1. Because if a case is already quashed at the PIC stage, then non-vet people may feel that you are favoring veterinaries. I think this was discussed at previous meetings, and even at in the presence of representatives from veterinary surgeons. Yes, I heard the comments. I'm just guessing whether it is Dr. Jiang's concern, because she has not she has not objected. I think I have guessed her right. I think whether when there is a food poisoning case, if I back the complainant, even if I'm accused of favoring him, I will say that it's not the case. So if there are 2 veterinary surgeons in the PIC, what if both members decide not to investigate the case? People will query the decision. Yes, we do understand this. We have accepted close to 700 complaints, and some are still pending a hearing. For those that have been handled, about 90% have been decided by the PIC not to be in breach of any professional code.
And these cases are withdrawn. Only 10% of the cases are referred to the board for hearing, and on hearing, in some of the cases, the veterinary surgeon concerned were found to be in breach of the code, and in some cases the license was suspended for up to a year, or the registration was suspended. And in our past experience, that we understand that we should let the vet know that he would not be let off lightly. But 17C, the point is that it's quite meaningless if it's in a ratio of 2-to-1. If investigation will proceed as long as there is no consensus, then we don't have much to say. Well, if all 3 members agree that there should not be an investigation, then so be it. But the point is, well, if we follow this logic, then comparing to the existing mechanism, this proposal is even more strict, because for PIC, at present there are 2 members. Once they cannot decide on an issue, the case will be referred to the board, and for the board it's in the ratio of 2-to-1, and the board will also follow the majority rule. And as mentioned just now, At the PIC, there must be a unanimous decision. Then, and when there are uncertainties, the case should be referred to the board for a hearing, and then as a result there could be more cases requiring hearings. Because we have the impression that such professional bodies may tend to defend their own members of the profession, and I'm not the chairman. I don't mind you tightening the requirement. I mean, if I were not the chairman of the BC, because we're here to monitor the professional conduct and performance of the vets. We should not relax the rule. So Dr. N. Chang's question was that she wouldn't object if you use the existing ratio of 1:1, but now in the ratio of 2:1, being 2 members being vets and 1 member being a non-vet, and if a consensus is not reached among the 3, then the case will not be further investigated, and we believe that the rule as a result will be relaxed. We don't want vets protecting each other. It's not that we don't trust the vets' professional conduct, but this is the impression you're giving to people. And once the legislation is enacted, it's difficult to revert to the original. Well, back then we believed that those doctors would behave in a certain way, but now some medical practitioners are actually protecting themselves and protecting each other, and they charge very daily, and there is no way we can change the medical council legislation. Well, you know, it's really difficult or cumbersome task to file a complaint, so on and so forth. So for those complainants, they're really aggrieved, and complaining to the board is the last resort. And yet, after they filed a complaint at the PIC, things are already very unfair because of the ratio of 2:1. Legally speaking, the complainant is disadvantaged. The complainant is the victim. So at the PIC, a vet will be deciding on whether the conduct of another vet would amount to professional misconduct, and undeniably there would be bias in favor of the vet. I think similarly, in other cases, well, for example, in a financial incident, somebody in the financial industry may find the incident no problem at all. So the insider may have a different angle than other lay persons. Now, we are concerned about this because for households with pets, there are hundreds of thousands such households. So many will be involved. If this appeal mechanism in future cannot protect the feelings of the pet owners or these households with pets, then I don't think this is a good mechanism. As for the ratio of 1:1, in fact, it may be helpful to vets as well, because they will be saved from performing a difficult task. Well, In fact, some pets may die anyway, and these vets know each other, and we have a mechanism to deal with conflict of interest. And you understand that it is absolutely an unfair trial for a vet to judge on his fellow. So this is my comment. So what is your comment? I gave her two suggestions, either going back to 1-to-1 or 2-to-1 with a consensus. So what is your suggestion? Should we consider that? I think it should be at least 1-to-1. In fact, it's best if all members are laypersons. I mean, 2 members are laypersons. At the final stage, during the hearing stage, you can have another vet on the board. You should not allow insiders to judge on their fellow. Mr. Chen Jishun, I want to know the intention of such a ratio. Why is it 1-to-1 or 2-to-1? And what about 2-to-2? Is it easier when it comes to voting? I think it's all about reaching consensus. One may say yes, one may say no, and then there will be no consensus, and then the case will be further investigated, and that's at the PIC. But now the suggestion is to have 2 vets and 1 layperson. And I said just now that if the 2 vets would like to protect their own profession, they would want no further investigation, and things would stop at the PIC stage. In the past, for 2 members. Now, even if without a consensus, the case would go back to the board. Now, if 2 vets agree that there should be no further investigation, that the matter would stop at that because of the 2-to-1 ratio. And that's exactly the problem. Chairman, as I explained just now, at present, at the PIC, there are 2 members, and they must reach a consensus and make a decision whether to dismiss the complaint or to refer it back to the board for hearing. And for cases without consensus, they will be referred back to the board for the board to decide whether to conduct a hearing. As for the ratio of the board, vets and laypersons are in the ratio of 2-to-1. And the board also adopts the majority rule so that unanimous decision is not necessary. And to streamline the procedure in our new design, at the PIC, the decision will be, or will be final. So we also like to have majority rule at the PIC. That's why the number of members is an odd number. As for the design, the purpose is to allow a vet to judge whether the other or the vet in concern is in breach of any professional conduct. And we understand the concerns raised by members, including Dr. Ann Chang. The complainant or the victim, as you put it, we understand that he or she may feel unfair to a certain extent. That is why all along we have a member who is a non-vet to strike a balance, to address your concern. And the concern over vets protecting members of their own profession. And as I mentioned just now, 90% of the cases will be dismissed. As for the reasons why the cases were dismissed, the board would need to, in black and white, inform the complainant of the decision. Ms. Lam, please don't repeat your answer. We understand. in the past, even with just 2 members at the PIC, for 90% of the cases, there was consensus. But now the burden is on the vet, so that with a ratio of 2 to 1, instead of 90, there could be 99% of the cases not requiring a hearing. In the past, it was 90%. Now it's 90. It could be 99%. So I don't think you understand the crux of the issue. What we don't want is to have vets protecting each other. Well, Chairman, even with a ratio of 2 to 1, we should not assume that this is the case. This is not an assumption. I even said just now that we can make the assumption that vets will not protect each other, just like myself, Tommy Zhang would not protect other members of the catering industry. But it's all about perception. Perception is very important. At the time of scrutinizing the bill, we should not allow an unfair ratio. So if you allow a consensus between the 2, then you should allow consensus among the 3, so that even if one of the members is not convinced, then there should be a hearing. Now, the problem exactly is because according to this ratio, as long as 2 members agree not to have a hearing, there won't be a hearing. That is not what we want to see. Well, Chairman, we want to clarify one point. At present, if there is no consensus, the case will be referred to the board for the board to decide whether to have a hearing. Well, Mr. Wong, I'm not dozing off. Please don't take me as having fallen asleep. I just returned from leave, but I did not fall asleep. At present, it's a case of in a ratio of 1 to 1 with consensus. So we ask whether a consensus must be reached even for a ratio of 2 to 1, and then you went back to all the arguments. To me, there is no difference. Well, please let me finish. Well, first of all, we must not assume that vets will protect each other. If there is a perception that, if the complainant believes that there should be further investigation, and yet the decision is that there is no further investigation, then what we're thinking is whether the board can have a second chance to review the case and to have another PIC to consider afresh. Because another PIC may have another layperson as a member, and the case would be considered afresh, and then we can also consider this. Because, but where do we see this in the bill?
If the first PIC decides not to proceed with an inquiry by a margin of 2 to 1, and then another PIC can be set up with the same ratio. Well, we need a CSA to do this. Now, if you're going to move a CSA, rather you change it to require consensus. I don't think anyone here disagrees with me when there should be a consensus. But if there is no consensus, then the case will be referred back to the board for a judgment. Otherwise, more and more cases, our worry is more and more cases would be referred to the IC. Now, currently the ratio is 1 to 1, and 90% of the cases did not require any inquiry. Is my understanding correct? Why do you feel that with 2 vets and 1 lay member, there will be over 90% of the cases with no consensus? Now, from what I gathered from members, now if there are 2 vets and the ratio is 2 to 1, no consensus required, I think there will be fewer cases being referred to the IC. I think no case will go to the IC if both vets have a consensus and consensus is required from that lay member as well. That's okay. Our concern is the 2 vets may be defending members of their own profession. Now, if the 2 vets think differently, then all the more there should be an inquiry. I think it is better for you to move a CSA to require a consensus, because even if you require the case to go to another PIC, then what if the PIC also protects the vet profession? Then where can we have justice? In the past, when there is no consensus, then there must be an inquiry. No, it will be referred back to the board. No, the board will decide whether the case has to be followed up. I think the most simple CSA is, with the agreement of members here, is for you to require a consensus of the PIC. But under the new system, we've removed the 2nd tier because we are for the sake of efficiency. The beauty of the ratio 2 to 1 is, now if the decision is to proceed, then the case will be referred to the IC. If there is no consensus, then it may go back to the board. Now, if the ratio is 2 to 1, then I think most members here, including myself, would think that 2 members should be lay members and the other one should be vet members. It would be easier for us to accept such an arrangement. Mr. Stephen Ho, well, we have been discussing these issues for a long time. Chairman, you're proposing that when there is no consensus in this PIC, then the case should be referred back to the board. Now, Chairman, I can't say whether I'm going to support you at this moment. Why don't we skip this point first and require the administration to give us more background information to convince us that this new system will be more effective, and to ensure that the 2 vet members will not be there to protect members of their own profession. Because even if we go on, I don't think, well, we can make our own CSA. We can propose our own CSA. I think it would be best if our proposal can be accepted by the administration. Ask the administration to think twice. Yes, we can come to a consensus, and by the time we vote, we know what's your view. Mr. Chen, we're not wasting time here. We want to convince the administration to move its own CSA to save time. Otherwise, this will be another chance for filibustering, because if at the 3rd reading, 2nd reading, there's so many CSAs. Now, if both the Pan-Democrats and pro-establishment members are for CSA, then if they disagree, perhaps they have to withdraw this bill. No, it's not our intention to do that. We plan to resume the 2nd reading of the bill before the 1st of February. That is before the policy address debate. If we cannot complete the bill today, then we may have to do it next week, and then it will be in March. Perhaps Mr. Chen will be happy to see that there will be more opportunity for filibustering. The administration claims that in the board, the ratio is also 2 to 1, but that doesn't mean that they will come up with the same conclusion. he's saying that in the board, the ratio is also 2-to-1. Now, if the board decides not to proceed, then we can accept that. After all, the board will be held accountable. The problem is in the PIC there are only 3 members and is vulnerable to manipulation. I just want to point out one minor difference. Now, at present, if there is no consensus, the board is to make that decision. In the future, if there is no consensus, an inquiry must be done, then it's different. Well. Now, if you're just asking us to refer it back to the board, we can consider that. If you're not asking for an inquiry to go ahead, I'm willing to consider this. We are willing to consider this. Because when the case is referred back to the board, perhaps another PIC can be set up and the result may be different. Yes, we are willing to consider this. And at the next meeting, we can either provide a paper or give a report to members. Now, you say that because the workload is heavier, you want more manpower for the board. But this section gives me the impression that you want to reduce the workload for the IC. Now, on the one hand, you are enlarging the size of the board, and yet you are trimming work for the IC. You can't do that because there are more animals in Hong Kong. All right. Is 17, are we done with section 17C, Ms. Lam? Yes. We will go on to section 17D here. These are procedural matters. Subsection 1 of 17D is when the secretary receives a complaint, it has to submit it to the PIC. And the PIC may request the following persons to provide information to facilitate it to make a decision. The complainant may be asked to provide more information. Perhaps the complaint itself is too simply drafted, and more information can be sought to facilitate a decision. And 2, the vet being complained of. To be fair, he should be allowed to provide information to the PIC. And the 3rd category is any person whom the committee considers appropriate. That can be any expert. For instance, if the surgery is very unique, then the PIC may consult a relevant expert to give objective views to facilitate it to make a decision. Subsection 3, the committee may then refer the complaint to an IC for an investigation or for inquiry. If the PIC decides to refer a case to the IC, then the secretary must, as soon as practicable, send to the subject person a notice of the referral and a statement of the substance of the complaint, and that is the particulars of the complaint, and also the justifications. Such information must be furnished to the vet being complained of as soon as practicable. Subsection 5, the notice and statements must be sent by prepaid registered post to the last known address of the subject person. Because that subject person is a vet, the board should have a record of his last known address. Subsection 6, if the PIC decides not to refer the complaint to an IC, then the secretary must, as soon as practicable, notify the complainant of the decision by prepaid registered post. Dr. An Zhang. Regarding 17D, 2B, and C, A PIC may request one or more of the following persons to provide information to facilitate the committee's consideration of the complaint. B. It is the registered veterinary surgeons being complained of. All right. I'd like to know whether that will include the clinic, because I know that there are clinics in operation that have employed veterinary surgeons or assistants, or I don't know whether we have veterinary nurses in Hong Kong, because in the process it might be the clinic or the nurse or the vet that has done wrong. Can all these people be included? Well, this is about the registered vet himself. We all talk about the vet in charge of the case. We are investigating whether he has had any misconduct. Then what about the investors or the operator of the clinic? Will he be allowed to escape penalty? Well, because the purpose of the bill is to regulate the professional conduct of registered vets. Regarding the case referred to by Dr. Jiang, perhaps the complainant will have to pursue through other channels. For instance, if the clinic is in the wrong, then the complainant may have to seek compensation elsewhere. Now, can you expand the scope of the section here? For instance, if I have started a pet hospital with registered vets in my employment, and yet I have not provided suitable conditions for vets to practice, and abuse of fees, for instance, the fees might be set by the clinic. For instance, for a cat suffering a cold, the fee is $1,000. For a dog suffering from a flu, $2,000, whereas the fees or the reasonable fees should be $500 or $600. Now, if the operator or the investor of the clinic is not included here, then what should we do? More and more people are abusing the situation. So I'd like to know whether the operator himself should also be held liable, and when can we regulate such people?
Well, perhaps we should seek some legal advice. Mr. Lai, any comment? Well, this amendment bill seeks to regulate registration of veterinary surgeons. As for clinic assistants and the clinic, as they're not included in the scope of the bill, we don't think it is appropriate to regulate the clinic and assistants under this bill. I understand that, but to their knowledge, whether this is it possible to regulate them through other pieces of legislation, or must the case be taken to court? Well, about Dr. Ann Chiang's concern, as explained by Mr. Lai, this bill is about registration of veterinary surgeons. So our regulation is about regulating veterinary surgeons, and we have this professional conduct here, and the code of conduct for veterinary surgeons, and any breach of this code may amount to a disciplinary offense. And the veterinary surgeon, as mentioned here, should exercise his professional judgment without influence, without being subject to influence by any other person. So if the operator of the clinic asked a veterinary surgeon to do something against his professional conduct, he should say no according to this code of conduct. Otherwise, if his conduct is below the level or the standard of professional conduct as set out here, it could amount to a disciplinary offense, and the vet will be subject to his registration being suspended or revoked if he is found to be in breach of the code on investigation. Well, but in reality, a boss may operate a clinic and to be honest, unless you are about to quit, you dare not disobey the boss. And I understand the plight of these vets. I think the government should regulate the trade comprehensively. Well, let's not discuss this issue here. I'll follow up on this issue at the FEHP panel. I'll follow up on this. Any other questions? If not, then 17D. 17D, as I said just now, the design is that once the case is dismissed, the complainant should be notified, but as discussed earlier, members asked whether there should be a consensus among the 3 members at the PIC, and that without a consensus, the case should be referred to the board for further consideration. And the DS just now already undertook to reconsider it. And if necessary, there will be a CSA on this section. And then Clause 12 of the bill amends Section 18 in relation to Inquiry Committee and Rules of Conduct. The first amendment is to repeal subsection 1 of Section 18. The existing Section 18 refers to the setting up of a inquiry committee. As in the future, the case will not be referred to the inquiry committee through the board. The subsection 1 will be repealed. Instead, new sections 1A, B, and C will be added. Subsection 1.8 states that the board may establish an inquiry committee to consider a complaint referred to the committee under Section 17D3. 1B. The committee is to determine whether a registered veterinary surgeon who is the subject of the complaint has committed a disciplinary offense. 1C. The committee is to consist of the following persons appointed by the board: and the composition is similar to the PIC membership as discussed just now. There should be 3 members of the board, of whom 2 members must be members of the board and 1 assessor. And in any case, 2 members must be registered veterinary surgeons, and 1 must either be a layperson who represents the interest of persons utilizing veterinary services, or a medical or health professional. This is the same as the same composition as that for the existing inquiry committee. Oh, Chairman, on this clause, then back to my same point. I don't care if it's PIC or IC. I want the representativeness of lay persons to be enhanced. For the IC, it's in the ratio of 2 to 1 at present, and we propose to retain the same ratio. But does it mean that 2 vets and 1 non-vet, or vice versa? Again, there are more vets as members than non-vets. Next amendment is to repeal subsection 2 of section 18. This is a technical amendment because the subsections is about the referral to the IC, and that the secretary shall send a notice of referral, so on and so forth. And this has already been dealt with in the new section 17D. Next amendment, section 18.4 in the English text shall will be repealed to be substituted by the word must. This is the prevailing practice of drafting nowadays. Similarly, in section 18.5 we have the same amendment, technical amendment, to replace shall with must. For section 18.5, subsection 2 will be repealed. It will be substituted by section 14D4. Next amendment, 18.6. In the English text, there are some amendments. The words shall be entitled will be repealed and substituted by is entitled, to which is the prevailing drafting practice or style. Next amendment, shall be provided, will be repealed to be substituted with must be provided. Next, 18.8a. In the English text, there are some amendments. The original wording is shall not be required to inquire whether here. This will be repealed to be substituted with must not be required to inquire whether the registered veterinary surgeon, to give it clearer meaning. Just a question, because we know shall and must carry different meanings, and you're saying that for the parts with shall, they are to be substituted with must, whereas there is no change in the Chinese version. The Chinese version should remain unchanged. Perhaps I'll defer to Mr. Lai to say more about this. In fact, for our drafting style, previously we had a briefing at LegCo, and we also have published a guide to law drafting, setting out the new drafting styles. In fact, shall and must carry the same meaning, but in order to make it more accessible and more easily understood, we have replaced shall with must. This is in line with international developments, and we are replacing shall with must whenever we submit an amendment bill to modernize the drafting. Next amendment, subsection 10, again to replace shall with must. Alright, then clause 13. You also have a paper, bracket 309/1415, bracket 01. Perhaps we will perhaps you should give us a briefing on this paper. Now, clause 13 seeks to amend section 28, and then there will be a new section 1A after section 28.1, and as explained in the paper, we would like to enhance the representativeness of the VSP and to encourage greater involvement of the veterinary profession in managing its own affairs. The bill proposes the addition of 6 members who should be elected by the profession, and in 28.1 we propose that the Secretary for Food and Health may by regulation provide for a number of matters such as the date, time, place and the procedure of the election. And in the paper on electoral matters, we have set out our preliminary ideas. Our preliminary suggestion is that, overall speaking, the incumbent board should be responsible for supervising the conduct of the election, and the incumbent board chair and members, excluding those who are candidates in the election, will form a board of review which will be responsible for handling any petitions related to that election. And we will talk about the board of review later. And members who are qualified to stand as candidates in that election and who are identified as being ineligible for becoming qualified candidates after submission of nomination, etc., will be excluded to avoid conflict of interest. And a returning officer may be appointed by the board, and this returning officer may be a member of the secretariat or any other members as the board thinks fit, and the returning officer should issue a notice of election at least 60 days before the election is held. As for the term of office of elected members, as mentioned just now, the term of office of an elected member is 3 years, and the member may be re-elected for a further term of 3 years each. As for the elected member, if the office becomes vacant under the newly added Section 2D3 of the Schedule 1, and if the unexpired term of office is not less than 9 months, the board must, as soon as practicable, hold a by-election to elect a qualified candidate to hold that office for the unexpired term. The term of office of the member returned through by-election is the unexpired term of the vacant office. And the term of office of an elected member starts from the first day of the month immediately following the date on which the election result is published in the Gazette. So this has been provided for. That means the first day of the month immediately following the announcement of the election result. As for qualification of electors, there won't be a separate registration for electors. All veterinary surgeons who are registered under the VSR ordinance will become electors as long as their names are entered in the register on the date of issue of the election notice, and they are qualified to vote in the election. And all electors are qualified to subscribe to the nomination of a candidate or to nominate a candidate in that election as a proposer or seconder. And there are 2 dates. An elector may be qualified to become an elector on the date of issue of the election notice.
And on the date of election, if an elector is no longer a registered vet, that is, if his name no longer appears on the register of veterinary surgeons, he will also be disqualified on the date of voting. In other words, his name must remain on the register on the date of election before he can vote. So that's the arrangement for electors. For candidates, all registered veterinary surgeons who are registered under the ordinance and whose names are entered in the register on the date of the issue of the election notice are eligible to be nominated as candidates, with the following exceptions. First, if he is the subject of an order made under Section 19 of the ordinance. Section 19 of the ordinance provides that where an IC finds that a registered veterinary surgeon committed a disciplinary offense, then the IC may make any one or more of the following orders, either to remove the name from the register, order the name to be removed for such period not exceeding 2 years, or may be reprimanded, or an order for the person to receive retraining. Anyway, if there is any order made under Section 19 of the ordinance, and if it is still enforced, then the registered vet would be disqualified. Second, an undischarged bankrupt. C, a vet who has entered into a voluntary arrangement within the meaning of the bankruptcy ordinance with his creditors, which is still in force, or if the vet is serving a sentence of imprisonment on the date of nomination, regardless of whether the conviction was in Hong Kong or in any other place. And fifth, if the vet is or has been convicted in Hong Kong or any other place of an offense for which he has been sentenced to imprisonment, whether suspended or not, for a term exceeding 3 months, where the election is to be held or is held within 5 years after the date of the conviction. In other words, if a person was convicted 5 years prior to an election and was sentenced to a term exceeding 3 months, he would be disqualified from becoming a candidate. Each elector may become a candidate only if she is nominated by at least one proposer and one seconder. And each elector may, in the capacity of a proposer or seconder, nominate more than one registered vet who is qualified. However, the number of candidates whom each elector may nominate must not exceed the number of elected members to be returned at the election. For instance, if in the first election there are 6 seats, then each qualified elector can only propose or second at most 6 members to be returned at the election. You mean one elector can nominate 6, at most 6? Dr. Zhang, can you allow her to finish first? You just jot down your questions. The next part is about disqualifications of qualified candidates. So if a person is a registered vet, he has been duly nominated by one proposer and one seconder. And if the following happens in between the period of a valid nomination and the date of election, then he is disqualified. First, if he has passed away, of course, he cannot take part in that election. B, he has ceased to be a registered vet. That is, his name has been removed from the registered. Or, if in the period an order has been made under Section 19 of the ordinance. D, if the candidate has become an undischarged bankrupt, or he has entered into a voluntary arrangement within the meaning of the bankruptcy ordinance with his creditors, which is still in force, or if he is serving a sentence of imprisonment on the date of election, or if he is convicted in Hong Kong or any other place of an offense for which he has been sentenced to imprisonment, whether suspended or not, for a term exceeding 3 months. An election will be held once every 3 years, and it is for the authority to decide on the date of the election. The by-election date, if required, will also be decided by the board, and the notice should be issued by the returning officer. On the date of election, it is our proposal that each elector may vote for more than one candidate, but no more than the number of members to be returned at that election concerned. For instance, if there are 6 seats, then an elector may vote for at most 6 candidates in an election. And the election method is the first past the post system. Say if there are 6 seats and there are 8 candidates, then the 6 candidates that get the highest number of votes win. And all electors are required to vote at designated polling stations within the specified polling hours on the election day. As pointed out by members, we don't want to waste too much money or to spend too much money on the elections, so they should be kept simple. There should be about 2 to 3 polling stations to facilitate voting by vets. And after all, we've only 700 odd registered vets in the territory, so there needn't be too many polling stations. Some members mentioned election petitions. We propose to add provisions on election petitions in the proposed election regulations. The regulation will set out the conditions under which petitions can be accepted and people who are eligible for making such petitions. We propose the petitions have to be submitted to the Board of Review within 30 days, after which the result is published in the Gazette. Dr. Jiang, you have a question? I've got 2. Will electors have to vote in person, or can that be done by email? Because it will be the first election for the profession, so the first election should be done in person. Will we allow voting by email in the future? That is for future consideration. You just told us that each registered vet may at most nominate 6 candidates. Does that mean that he is entitled to cast up to 6 votes? Yes. Well, for bigger organizations with 600 members, and they will be able to monopolize the election. Ms. Lam. It's true that we have veterinary professional bodies in Hong Kong, and they are entitled to vote as they like. And if one body field 6 candidates, and if they are supported by other registered veterinary surgeons, that is fine. Well, in Hong Kong, many elections, such as electrical elections, will only allow one person to vote on one candidate. How come you will allow people to to cast 6 votes? Because a large clinic may have hundreds of employees, and they may be able to monopolize or to control the election. You must think twice. This is very problematic. Ms. Lam? Yes, we can reconsider this point. In our design, each registered vote can vote for 6 candidates because there are 6 seats. We will consider whether we can limit the number of votes to 1, but still I should put it the other way around. we propose that the 6 candidates that get the highest number of votes will win. I agree that each elector should be allowed to vote for one candidate, because under the current system there can be the possibility of large organizations controlling the result of the election. And I don't think it is necessary to consider any proxies. You just told us that for the first election you will make it stricter, and in the future you may consider other methods of polling. But that means you have to propose legislative amendments in the future. We do agree that for the first election we have to verify the qualifications of electors. So electors are required to vote in person, and we do not provide for proxies. But as technology advances, while at first time we'll adopt the most primitive approach, and that is voting in person. In future, we may consider other methods. Email, well, I did not make myself clear. We have to ensure internet security, and there will, for instance, no hacking of computers. But I don't rule out the possibility that when technology permits in the future, we can allow other methods. Well, will the regulations be passed by negative or positive vetting? Negative vetting. And that is not what Mr. Chen likes to see. Many legislators in the Council do not like regulations to be passed by negative vetting, given that this is such an important piece of legislation. Because you just told us that you may consider other possibilities in the future. Maybe you and I won't be around anymore. I may not be in Hong Kong, but if I'm allowed to use email to vote, this can be very controversial. Yes, entirely agreed. Well, we are not proposing anything. Then you should not mention it. Otherwise, members will ask you questions and they're not happy about this. I agree with the chairman. I was about to ask whether similar setups allow such flexible mode of voting by accepting emails or posts from overseas, so people are allowed to vote even if they're not in Hong Kong. Now, if we involve such complexities, I don't think we can complete in this year. We can do it slowly then.
Well, I want to supplement. I mentioned that voting could be done by post or by email because at the second meeting of the BC, we received deputations with representatives from the sector, and this idea was floated. Of course, for the first term election, we will not try to implement it, but yes, indeed, there is a suggestion. But I agree, let's not discuss anything in future, let's discuss the present. Dr. Kenneth Chan. The election method is important to enhance representativeness of the profession. On the arrangement for one elector to cast 6 votes is unhealthy, because in Hong Kong we have some kind of elections with the same arrangement, adopting the block vote mode for the CE election or other elections, and as a result, the result may be a domination by a certain large party, and therefore, some members are concerned, expressed just now, whether some larger groups may be able to dominate the election. Now, you may consider having more seats and fewer votes for an elector to cast. For example, one person, one vote, or perhaps just one person, three votes to encourage competition. And there is a term for it in a public hearing. I also raised the same issue. Some deputations also suggested that voting be cast through email, perhaps because in the UK the country is bigger and it may be difficult for members to travel all the way just for voting. But Hong Kong is a small city, it's very convenient. I don't suggest that we consider voting by electronic means or by email. I think 1 or 2 polling stations should allow all members of the veterinary profession to cast their votes. At this stage, I appreciate your effort for telling us your preliminary idea, but please consider carefully whether the election should be made by one person, one vote, and for independent veterinary surgeons, their participation can also be allowed instead of the election being nominated by larger groups. For colleagues here attending this meeting, not many members support your preliminary idea. So please go back and discuss the voting arrangement. If you change this to one person, one vote, it means for nomination, a candidate or an elector can only nominate one candidate, and you need to prepare CSAs. It seems inevitable. No CSAs are necessary at present, at this stage. I know this can be done later, but you need to give us a response, and our members also need to wait for your response and decide whether we should do CSAs if you're not doing them. And we still have 25 minutes. Then we can finish the clause-by-clause scrutiny, save for the part about CSAs. Well, Chairman, about the point you raised, we also need to consult the DOJ on voting arrangement, and then we'll revert to the BC. Coming back to the clause-by-clause scrutiny, Section 28, we are adding 1A to empower the Secretary for Food and Health to make regulations. Clause 14 of the bill amends Section 29. This is a technical amendment, 29(2) in the Chinese text about the Food and Health Bureau. As in the bill, we are going to have an abbreviation that is the Secretary for Food and Health, and therefore we're going to repeal this term in Chinese, Food and Health Bureau. Clause 15 seeks to repeal Section 30. Clause 16 seeks to amend Schedule 1, provisions as respects the board and its members. Now, for the title or the heading, the Assistant Legal Advisor has noticed that we have left out the panel of assessors, so we're going to amend the heading to include that as well. As for Schedule 1, it contains technical details, and in Schedule 1 we are going to add new sections, including 3C, 3D, 3E, 4, 17B, and 28. I'm sorry, a mistake. In Schedule 1, my first amendment is to repeal sections 4 and 28. And we'll also add the new sections as I mentioned just now. And in Schedule 1, we also propose to repeal sections 1 and 2 because these two sections will be replaced by the new sections 2A to 2E in the following. So the original sections 1 and 2 are proposed to be repealed. And then we will add 2A to 2E. 2A has to do with resignation. A person holding the office of the chairperson or an appointed member may, by notice in writing to the Secretary for Food and Health, resign from the office. A person holding the office of an elected member or an assessor may, by notice in writing to the chairperson, resign from the office. A resignation under this section takes effect on the date specified in the notice given to the Secretary for Food and Health over the chairperson, or, if a date is not so specified, on the date on which the Secretary for Food and Health or the chairperson receives the notice. Moving on to 2B, the Secretary for Food and Health must declare that the office of the chairperson becomes vacant if A. the chairperson dies, B. the chairperson resigns under the section I mentioned, and C. if the chairperson is a registered veterinary surgeon. In respect of the chairperson, there is an order under Section 19 in force in relation to disciplinary offense. And D, the chairperson is an undischarged bankrupt or has entered into a voluntary arrangement within the meaning of the bankruptcy ordinance with his or her creditors, which is still in force. E, the chairperson is sentenced to imprisonment for a term exceeding 3 months. Or F, the Secretary for Food and Health is satisfied that the chairperson is unable or unfit to perform the duties and exercise the powers of a chairperson because of physical or mental illness or any other reason. Under these circumstances, the Secretary for Food and Health can declare that the office of the chairperson has become vacant, and the vacancy will be notified to the public by way of notice published in the Gazette. If there are no questions, I'll move on to 2C. 2C is about the office of appointed members declared to be vacant. The situation is similar to that of a chairperson. If an appointed member dies or resigns or is ruled to have committed a disciplinary offense, or if the appointed member, originally being a registered veterinary surgeon, is no longer a registered veterinary surgeon, or vice versa, the office would become vacant. If the appointed member is sentenced to imprisonment for a term exceeding 3 months, or the Secretary for Food and Health is satisfied that the appointed member is unable to unfit to perform the duties and exercise the powers of a member because of physical or mental illness or any other reason, and the Secretary for Food and Health must declare by notice published in the Gazette that the office becomes vacant. If there is no question, I'll move on to 2D. 2D is about elected members. That is, for elected members returned under the election regulation, if he or she dies or resigns, or has committed a disciplinary offense or ceases to be a registered veterinary surgeon or an undischarged bankrupt or sentenced to imprisonment for over 3 months or is found to be unfit or unable to perform the duties and exercise the powers of a member because of physical or mental illness, the Board may declare by notice published in the Gazette that the office of an elected member becomes vacant. For 2E, it's about assessors. And the arrangement is similar to what I mentioned just now in relation to an elected member, and I won't repeat them. Schedule 1, Section 3 is about procedures of meetings, and we have added a new heading to provide clearly the purpose of each section. In the new section, we have added a heading for each section. And for subsection 2 of section 3, again we have replaced shall with must. And in section 3.3, the shall will be replaced not by must but by is to. Also some other technical amendments in section 3.4, again to replace shall with must, and in a Chinese text the Food and Health Bureau will be replaced by Secretary for Food and Health in Chinese. And also there is a new heading for section 4. And then in English text section 4, shall be will be replaced by is, and also some amendments in the English version. These are technical amendments. Moving on, part 3. We've kept some savings and transitional provisions. As the board is still in operation and it will continue to receive complaints, and under the new ordinance, a new board will be set up, and the complaint handling mechanism is different. We need savings and transitional provisions as a result to deal with complaint lodged and received before the new ordinance takes effect. We need to provide the legal basis. And we've also included some interpretation. Including the commencement date of this part of the bill, part 3.
And also PIC, which means PIC established under section 17C1 of the amended ordinance, with also added definition for pre-amended ordinance, which means the VSRO is enforced immediately before the commencement date, and then the term new inquiry committee, because there is always an IC before and after the amendment. So we have introduced this new term, new IC, to make a distinction. And also interpretation for amended ordinance and for the board, and there is also the old board. And then 18, complaints not yet referred to the board under Section 17(3) of the pre-amended ordinance. That is, complaints received before the commencement of the amended ordinance, if they have not been disposed of. So if a complaint alleging a disciplinary offense is to be dealt with by a preliminary investigation committee under Section 17D of the amended ordinance, if it were a complaint submitted to the committee under Section 17D1 of that ordinance, if before the commencement date the complaint was submitted to 2 members of the board and those members had not yet made the determination for the complaint under that section. In other words, the complaint will be decided by the PIC as to whether it should be squashed or should be quashed or referred to an IC for determination. 19. Complaints referred to the board under Section 13(3) of pre-amended ordinance. For cases already referred to the board, which has yet to decide whether they should be referred to the OIC for determination. Such cases will be referred to the new IC as if it were a complaint referred to the committee under Section 70D3 of the amended ordinance. Clause 20 deals with another scenario, i.e., complaints referred to an old committee under Section 18(1) of pre-amended ordinance. So the complaint has been referred to the old IC already, but the old IC has yet to determine the case. So it will be handled by the new IC. The last scenario deals with new inquiry committee to make disciplinary order for an old inquiry committee's finding. So an old IC has already made a decision but has yet to lay down any disciplinary order. So it will be done by the new IC as if it were made by the old IC. All right. Any questions? If not, we've completed the clause-by-clause scrutiny of the bill. Chairman. Chairman, under your leadership, members of the BC have expressed our views to the administration. I urge the administration to give serious consideration to our suggestions. If they can move their own amendments, the best. Because if the administration doesn't do so, we can always move our own CSAs. Of course, we don't want the latter to happen, because if any of our CSA is not passed, the administration might have to withdraw the bill. So the composition of the board, the composition of the PIC and the IC, and other matters, we want the administration to ensure a ratio of 1:1 as far as possible, if not 2:1, with 2 being lay members and 1 vet members. And we've also made known our views on the nomination and election methods. If the administration wants the bill to be passed, it must give serious consideration to these points. Dr. Zhang, if you would like to move your own CSAs, you may do so, referring to points you mentioned just now. And regarding the ratio of 2 to 1 or 1 to 1, and if there is no consensus, should the case be referred back to the board for its consideration, I think that's the only point. We wait for the administration's response. For other matters, such as election methods and the number of votes an elector can cast, that can be dealt with when the regulations are submitted to us for negative vetting. And I hope that the Secretary can respond to our concerns on the election method in his second reading speech. Given that there are only 700 odd electors in this profession and there are only 6 seats, how come it is not a one person, one vote system? Because we don't want the election to be controlled or manipulated by a bunch of members in the profession. If the administration needs to report back to us if necessary, I think we can convene another meeting. Yes, I would like to brief members on the legislative timetable. If we want another meeting next week, then the 12th of January at 10:45. With the exception of Mr. Raymond Chen, all members are available. And it is up to Mr. Chen to decide how he is going to shuttle between different meetings. If members have their own CSA, it would be desirable if we can have them within this week so that we can have a week to read them ourselves. And the same applies to the government. If we agree to meet on the 12th of January, then, though it is cutting it a bit fine, still we can have the bill to resume its second reading on the 4th of February. Is there another possible date? Apart from the 12th of January, it would be hard. It would not be before the 26th. As you all know, we are bundled up for sittings on Wednesdays, Thursday, and Friday. We only have Monday and Thursday left. Can't we find another date? Well, it depends on the availability of rooms as well. We have such a small membership, only 1 member plus 3 members. We can have a smaller venue. But in fact, we have more members in this BC and they can always come. You know, there's the policy address on the 14th, and after that, we're very full. We can't even find a room. All right, 12, because on the 12th of January, I won't be available from 10:45 to 12:45. Then there is no helping it. But of course, Mr. Stephen Home may not necessarily represent you. I wonder if we need another meeting and whether you want to move your own CSAs. Anyway, if members would like to have the bill to resume its second reading debate on the 4th of February, then we need to submit a report to the HC on the 23rd of January. A notice for the administration to give notice is the 26th of January, a Monday. The deadline for members to give notice of CSA is also the 26th of January. Mr. Raymond Chen. First, why the rush? Why the rush? No, we're not in a rush. We want the administration to tell us whether it is going to move any CSAs. If yes, there is no need for us to move our own, or perhaps they do some, we can do the rest. All right, then let's fix the date for the 12th of January 1st. No, you just asked 2 members and they are not available. Now, if we fix the meeting on the 12th of January, I will require them to give us papers by Thursday because we need to read them. Chairman, we have 4 members present. No, 5. Okay. Well, 4 members on this side. I'm not available. Mr. Chen is not available. Well, he didn't say no. No. Mr. Raymond Chen is not available. How about Professor Kenneth Chen and Mr. Paul Tse? Are you 2 available? If yes, then you should be here. Don't represent me, okay? No need to represent me. You asked why the rush. No, that there is no need to rush. The question is, I just want to remind members that after next week, if we cannot beat the deadline, then the second reading debate may be in March. And then there is also the policy address and budget. I don't think they can be passed because of filibustering. If you ask me whether we're in a hurry, of course not. But if not the 4th of February, it will be the 18th of March, the earliest. No one wants to procrastinate here. I think it is our consensus to pass the bill, although there are things we don't like in the bill. Dr. Jiang, if you have CSAs, you can submit them and we can still discuss it in your absence. Even if you're not here, I will need members to discuss them. And if we are indeed going to meet on the 12th, I hope that they can tell us by the 8th whether they are going to move any CSAs. If yes, what? Or first I'll ask whether the administration is ready. Will you be able to give us a paper by Thursday? We'll try our best. No, don't say you just try your best. Yes, we'll give you a reply by Thursday. Let us know whether you are going to move any CSA. If yes, what would they be? So tentatively, we're going to meet at 10:45 on the 12th of January. And if members of CSAs, please try your best to give us those CSAs by Thursday. But what? I can only submit them to you or present them or table them on the 12th?
No, I'm saying that it's best if you submit it by Thursday. Even if we don't discuss your CSAs here, you can still submit CSAs on the 26th. But then we can't discuss it until the CSAs are tabled in the council. We may want to discuss the CSAs for you to lobby members' support. And you may also want to have a consensus and for chairman of the BC to move the CSAs, and we can discuss them on the 12th. And if so, you can prepare the CSAs for members' reference. But there are uncertainties if we cannot make it before the 4th of February. We will wait till our next opportunity in March. So tentatively, our next meeting is scheduled for the 12th. Well, the administration, if it is unable to give us an answer, we will postpone it. Thank you.